The clerk will read the bill.
HB number 126 by Tepper, relating to the compensation and professional representation of prospective student athletes and student athletes participating in intercollegiate athletic programs at certain institutions of higher education.
The chair recognizes Mr. Tepper to explain the bill.
Thank you, Mr. Speaker. House Bill 126 updates our state's name, image, and likeness law to keep our university athletic programs competitive and ensure we retain top student athletes in light of expected changes in the NCAA rules. The NCAA has historically barred schools from using NIL deals to recruit or retain student athletes, but a pending settlement will dramatically change how student athletes and universities engage in NIL agreements. We're expecting a finalization of...
Ms. Gervin Hawkins, for what purpose?
Will the gentleman yield for a couple questions?
I'd like to finish my layout, and then I will yield. Thank you,
Not at
ma'am.
this time.
My bill has three primary components, and this might answer some questions. HB 126 allows universities to enter into direct NIL agreements with student athletes, which may include financial compensation and offers of admission. My bill removes current restrictions and allows NIL agreements to be offered or engaged before a student athlete enrolls, before they enroll. Lastly, the bill provides flexibilities by allowing universities and student athletes to comply with future court orders or new rules from the NCAA or athletic conferences. There are a few things the bill does not do. HB 126 does not change academic eligibility requirements. Student athletes must still maintain good academic standing under NCAA and university policies to be eligible for NIL compensation. The bill does not allow student athletes to receive NIL payments before enrolling in a university. The bill would allow prospective student athletes to enter into NIL agreements, but they must be an enrolled student athlete at the institution to receive an NIL payment. They've got to show up. My bill will not adversely affect high school sports. UIL rules continue to prohibit high school students from receiving NIL payments. If they take an NIL payment, they will become ineligible to compete in high school. My bill does not permit pay for play. NIL compensation cannot be based on athletic performance. You can't get paid for 1, 2, or 3 touchdowns. My bill does not authorize the use of public funds for NIL payments. The athletic departments are independent. They make their money off TV, ticket sales, suites, concessions, that sort of thing. My bill does not remove the current requirement that student athletes complete a financial literacy course. They must complete the course. Lastly, my bill does not change our university's obligation to follow federal law and all applicable NCAA and conference rules. Members, we must pass this bill to keep our university athletic programs competitive. Other states are already updating their NIL laws in anticipation of NCAA changes. They have full-time legislatures, and chances are they've already changed their laws or are changing them right now. I yield for questions.
Ms. Gervin Hawkins, for what purpose?
Gentleman yield for questions?
The gentleman yield for questions.
I will yield.
The gentleman yields.
Representative Tapper, I have a great concern about the NIL program. And maybe Texas can be the state that looks at it a little different. Are you aware of what the repercussions are when young people get money and they can't maintain that level of lifestyle and what happens over time? Have you looked at that at all?
I look at it as an opportunity for these athletes. They're finally being given consideration for their hard work, their natural abilities, and performance. Again, they have to take the financial responsibility course, and I certainly recommend that they follow the instructions from those courses.
Were you aware that then the colleges don't have direct contact with these athletes? It's normally through their agents?
I am aware that the colleges may directly engage these athletes. I am also aware that the athletes may engage legal counsel or other professional counsel.
Representative, you know, I agree with you that our athletes need compensation because naturally the university is making dollars. But what I'm wondering is, does your bill put any stopgaps or protections, whereas some of these dollars could be put in a trust fund and they can get it at the earlier, whichever happens earlier, graduate college or become a certain age, to kind of protect our youth from not falling into the trap of back taxes, bad investments, family disruption? Have you considered any of those things?
We are not going to micromanage where the money goes. I'll also have to say that these colleges are limited to $20.5 million a year for their athletic program. So the concept that a high school football player is suddenly going to be inheriting $1 million from these programs is very unlikely. There might be a few $1,000s consideration, certainly not enough to change the lifestyle, but enough that there is some compensation for their efforts.
So, Representative, were you aware some athletes are getting $1.2 and $2 million? Were you aware of that?
You mean professional athletes or NCAA athletes?
NIL, the NIL program.
I'm not advised.
Well, I can tell you with firsthand knowledge that a lot of these players are getting in the millions of dollars and being offered that. And my concern is, again, protecting them not just in the short run, but the long run. Would you be open for a friendly amendment?
I am not open to an amendment right now, and if they can get $1 million, I recommend they take $1 million.
Thank you for answering my questions.
Thank you, Representative.
Mr. Little, for what purpose?
Does the gentleman yield for questions?
Will the gentleman yield for questions?
I yield for questions.
The gentleman yields.
Thank you, Representative Tepper, for your layout. You attended Texas Tech University, right?
Yes, sir.
All right. Did you happen to see the game on August 31st, 2024 between Texas Tech and Abilene Christian University?
I did, yes.
So my recollection is Texas Tech won that game 52-51 in overtime. Do you remember that game?
Yes, it was a nail-biter, yes, sir.
Aren't you concerned that in this current NIL environment, that if we allow universities to make direct payments to athletes, that we're actually going to grow the gap and distance between schools like Texas Tech, A&M, and Texas with schools like Abilene Christian and Rice and Baylor?
Personally, I'm concerned. Professionally, this is a decision of the courts. This is an NCAA settlement with the court system, and you can take that up with them, Counselor.
Well, respectfully, if it were a decision of the court, we wouldn't need a bill. So I'm asking you questions about this bill because I have concerns that this represents a trajectory for college athletics that doesn't end anywhere good. So is there anything in your bill, Representative Tepper, that precludes the use of taxpayer funds for a purpose of solicitation or recruitment of a college athlete?
The athletic departments are independent. They do not take taxpayer funds. They are funded through, as per the layout, through the sale of suites, television, concessions, and tickets.
But one of my concerns is, and I think the answer is no, I don't see anything in your bill that prevents a university from expending taxpayer funds for this purpose of engaging in NIL contracts. In other words, I don't think the bill is clear that these contracts are between athletic departments and the student athlete, but rather the university and the student athlete. Do you agree?
I'm not advised, and there also might be other sections of code that handle student athletic departments versus the university systems themselves.
All right. And Representative Tepper, I understand that this bill would entitle the university and all of its agents of the university, coaches, administrators, to make binding offers of admission in conjunction with university-centered NIL contracts. Is that fair?
Give me that question again. Do the coaches make offers?
It sounds to me like in the bill that the university and its agents will have an opportunity to use these NIL contracts to make binding offers of admission and recruitment to the university. Is that right?
Yes.
Okay. If so, Representative Tepper, based on your bill, if the university breaches its NIL contract or its NIL offer to the student athlete, can the athlete sue Texas Tech for breach of that contract?
Well, I believe there's sovereign immunity, but I don't, I'm not advised.
I'm concerned about that issue. I'm glad you brought it up. I'm seizing on it too. It seems like an athlete who's part of an NIL contract cannot sue Texas Tech. They cannot sue the University of Texas or A&M or the University of Houston, but they can sue Rice. They can sue Baylor. They can sue Abilene Christian for breach of an NIL contract, don't you think?
It's America. Certainly you can sue.
So, Representative Tepper, one of the concerns that I have is this bill provides for the direct payments of cash to the university, from the university to the student athlete in exchange for their participation in collegiate athletics. Is that right?
That's correct. That's how it's been operating for the last few years, Representative.
Well, no, it's not, because Texas Tech has an NIL collective, right?
Texas Tech is in the NIL, yes.
Yeah, so these NIL collectives that are formed by the individual universities are groups generally of donors outside of the university, aren't they?
Yes.
But this bill takes that regime, this NIL regime, and moves it in-house to the university to allow the university to assume those obligations, doesn't it?
Okay.
Isn't that what it does? Isn't that what it does?
No, not necessarily. No.
Okay. So the way that I read the bill is a student athlete can be compensated for any act during an official team activity. Is that under your bill? That's how I read it anyway. Is that right?
They can be compensated for their athletic abilities, yes.
Yeah. It says that the compensation for the use of the student athlete's name, image, or likeness is provided in exchange for an act, and this portion is being deleted, in exchange for an act that occurs while the athlete is engaged in an official team activity. And we're removing that from the bill because we want to allow the university to compensate the student athlete for those team activities, right?
Correct.
So in your layout, I
For
heard
their,
you...
and just to be clear, for their name, image, and likeness.
Yes, but I think I heard during your layout that this isn't a pay-for-play bill. It seems to me that the bill will permit
Well,
pay-for-play.
pay for play means, how many touchdowns, what's your performance, how fast you can run a yard, that sort of thing.
One of the concerns that I have about your bill, Representative Tepper, is it seems like we are coming a lot closer to making student athletes who are on scholarship employees of the university. Are you concerned about that at all?
In the bill, they are specifically not employees of the university.
And I understand it says that in the bill from a previous statute. The problem is when a student athlete engages in things that make them appear to be an employee, at some point the law finds them to be an employee of the university. And these direct payments from the university to the student athlete are going to raise that legal concern at every university in the state of Texas, potentially subjecting those universities to Fair Labor Standards Act, being unable to terminate them for purposes, or if they are subject to a disability. There are very significant federal law implications as a result of making direct payments from a university. Does any of that concern you?
I think the entire nation is concerned, but we didn't bring this to them. They brought this to us. The court system brought this to us, and it's still shaking out as we speak.
Can these student athletes unionize?
They cannot.
If these student athletes get injured, are they entitled to workers' comp?
I know that there are insurance policies paid for by the athletic department.
Are you familiar with a gentleman named Cody Campbell?
Yes.
So I just read the newspaper. My understanding is Cody Campbell is a very significant donor to Texas Tech University. Do I have the right Cody Campbell?
Former football player and a donor, yes.
And from what I understand, very successful businessman. My concern, and I hope you'll answer this question, Representative Tepper, is what are the other universities to do who don't have a Cody Campbell or an Elon Musk to help facilitate the athletic endeavors of their university? How can they possibly compete?
Again, Representative, these schools are capped at $20.5 million a year.
Do you know how much money SMU or Rice or Baylor or any of the small private universities in Texas commit to their NIL collective?
I'm not advised.
As a reminder, members, you may not engage in personalities during debate.
Representative Tepper, one of the concerns that I have is that we're entering an era of, and it's not your fault that we're where we are. This is a very complex topic, but this is it's an important one that we as a state need to consider, that we're entering an era of name, image, and likeness in collegiate athletes where we essentially are having to suspend our disbelief that these student athletes are anything but subcontractors to the university brought in for our entertainment. And I would just pose the question to you, is this what we want in collegiate athletes or in collegiate athletics in the state of Texas? Do you think?
I do agree that these student athletes deserve to be compensated.
All right. Thank you, Representative Tepper.
Thank you, Representative.
Mr. Lambert, for what purpose?
Mr. Speaker, would the gentleman yield?
Will the gentleman yield for questions?
Yield for questions.
The gentleman yields.
Representative Tepper, could you just confirm once again that no taxpayer dollars would be used to pay any NIL contract that a university extends?
I've been advised that no taxpayer dollars will be used. The athletic departments are independent.
And would you agree that if this bill does not pass, this puts our universities at a distinct disadvantage in terms of recruiting nationwide?
We will be killing college football in Texas if we do not pass this bill.
Thank you, Representative Tepper. I think it's a great bill.
Thank you, sir.
Ms. Jones, for what purpose?
Yes, will the gentleman yield for questions?
Will the gentleman yield for questions? Will the gentleman yield for questions?
Yield for questions.
The gentleman yields for questions.
Thank you. Question. As a former scholarship athlete, are you saying that Texas universities will now be able to give NIL contracts to prospective student athletes
That's correct.
and no taxpayer dollars will be used,
That's correct.
but the universities will get the money from who? Boosters or whatever?
Well, mostly these athletic departments are paid for through the football program. Football is king. Some money is from basketball, a little less from baseball, but mostly football and mostly the athletic department through television contracts, tickets, concessions, selling suites, that sort of thing.
So it'll be the money that is used to I guess, give these NIL contracts are from TV. I guess you're saying from football concessions. What about girls' sports? Is there something? Does the money? If let's say the money comes from football.
Title IX doesn't change. Some universities, not all of them, but some of them are electing to distribute to Title IX or women's athletics or any of the athletic programs based upon the percentage of income those athletic programs bring in. Some might use it by ticket sales, some might use it by monetary income, and that's still undecided. So a lot of it I am not advised.
And so the money might also come from boosters?
That is correct. And it can also come from advertisers.
So, but right now, boosters can't give an athlete money to get them to come to a school. Would you agree with me?
Can a third party incentivize an athlete to come to a certain school? Is that your question?
No, my question is, can a booster from whatever school who wants a five-star recruit, can a booster pay that recruit to go to a certain school right now?
Under the rules outlined in the bill.
No, I mean like before your bill. Is a booster allowed to use their money to get an athlete to come to a certain school?
No.
So, but under your bill, a booster can give money to the athletic department.
And Representative, let me be clear. Before this bill, there was already payments to these athletes. So how these payments were structured and from what booster, I'm just not advised.
Right. So here's what I'll tell you. When boosters would give money to athletes to get them to come to a school, a bunch of schools got the death penalty. Take SMU, for example. Right? So I guess my question is, can the boosters now, rather than giving money directly to the athlete, give the money to a school, and then so they can basically run the pay-for-play to get the athlete to go to the school, is my question.
Well, again, the universities are subjected to a $24.5 million cap per year. There's a cap.
Yeah, I don't know if that answered my question. So
I'm not sure what your question means.
So you know what? Maybe it's
the boosters can give to the universities, but there's still a cap.
But so now the boosters, instead of giving to the athlete, which they clearly cannot do, can now give to the school. The school can give it to the athlete to get the athlete to come there. Is that accurate? And with whatever the cap is.
But if there's a budget of $20 million and the booster gives 10 million, it's still capped at 20. There's only another 10 million that comes from other places.
Right, but I just want to know if a booster now can give money to the school instead of giving money.
The gentleman's time has expired.
Thank you.
May I make a motion?
Mr. Little, for what
Motion-
purpose?
Motion to extend time.
Members, you've heard the motion. Is there objection? Chair hears none. The rules are, the gentleman's time is extended.
Representative Tepper, I'm sorry. Mr. Speaker,
Mr. Little, for what purpose?
does gentleman yield for
The
questions?
gentleman yield for questions.
I yield for
The
questions.
gentleman yields.
Thank you, Representative Tepper. So, Representative Tepper, do you really think that without this bill, that Texas is not going to be competitive in college football?
I am absolutely certain that we will not be competitive.
We don't have your bill now. Texas just finished in the Final Four for purposes of the national championship, right?
Right. This bill is due to a court order or a court decision that's coming down. It's already been summarily decided. It's coming down within the next week or two.
And Representative Tepper, we don't have your bill now, but Texas Tech just finished in the Elite Eight in college basketball, right?
That's right.
Here's my big concern, and this is the big question for you. What am I supposed to tell a collegiate athlete who has entered into an NIL contract with the university, that when the university decides he or she stinks at the sport and shouldn't be at the school anymore, that they cannot sue to enforce that NIL offer against the university? What should I tell that person?
So you're asking if the student athlete can be released.
No, my question was different. The university enters into an NIL contract with a student athlete, says, we're going to pay you $4 million to come and play college football here. And then they get on campus and the university decides, you stink, we're not going to pay you the rest of this NIL contract. What am I supposed to tell that student athlete concerning his ability to collect against a university that's subject to sovereign immunity? Should I just tell him too bad?
Well, Counselor, you're going to have to read the contract that the university gave them. You should know that.
The contract doesn't matter because the university is immune from suit unless the people in this room decide that they're not, right?
And I am anticipating that agents will be guiding these students through and know their rights and ability through the contract process.
Representative Tepper, I very much appreciate your taking my questions. I cannot support this bill. I think the trajectory of college sports is going somewhere that is very bad, not only for Texas, but for the United States.
Mr. Buckley, for what purpose?
Would the gentleman yield for a question?
Will the gentleman yield for questions? The gentleman
I
yields.
yield for questions.
Yeah. Representative Tepper, does Texas have any control over the settlement of the lawsuit?
No.
What would the effect be if we fail to pass this legislation in terms of our competitiveness amongst our college athletes
Sure.
in a vacuum?
Florida, Georgia, Alabama, Michigan will be able to recruit our student athletes from around the country, and give them a certain deal to attend their university and play sports for their college.
So failure to pass this bill would put Texas athletics and our universities at a competitive disadvantage?
At a huge competitive disadvantage.
All right. Thank you very much. You got a great bill.
Yes, Representative. Thank you.
Mr. Tinderholt, for what purpose?
Will the gentleman yield for
Will the
questions?
gentleman yield for questions?
Yes, sir, I will yield.
Gentleman yields.
Is it possible to waive the immunity piece in these contracts, or for the legislature to actually do it in your bill? And let me tell you why I'm asking. If someone gets selected to go to, I won't name a school, they just get selected to go to a school, and they get an awesome deal, and then the school breaches the contract. Right now they can't sue, but they could have gone somewhere else that might have followed through with their contract. So I'm wondering if there's a way in this bill to do an amendment that would make sure that immunity does not exist in this instance, in these types of contracts?
Representative, sovereign immunity is a larger issue than this bill. And so right now, I would not accept any amendments.
Okay, thank you.
Thank you, sir.
The chair recognizes Ms. Gervin Hawkins to speak against the bill.
Thank you, Mr. Speaker. Members, I've been around sports all my life. I know what it can do for you, and I know what it can do to you. Now, I know that NIL is big across the country, but one thing that I hope is in the state of Texas, when we do it the right way. I want to give you a couple examples. You have an 18, 19-year-old child who gets $1 million, buy a bunch of new shiny items. What can you tell them what to do? You can't. There's no incentive to graduate college. You will destroy family, parent-child relationships, and you will create problems for folks beyond what we see today. Should the state of Texas be engaged in NIL? Yes, but let's do it the responsible way. I've seen athletes lose everything, have millions of dollars, but didn't pay their taxes. What happens? They buy a bunch of shiny new items that they can't maintain or keep. I believe athletes should be paid. I've always believed that. In my days of college, a lot of those young men and women got in trouble because they weren't getting what I call just a basic allowance to be able to buy food. So yes, I'm a big believer in it happening, but I'm hoping the state of Texas can do it the responsible way. I've heard from my colleagues that across the country, NIL is big. That's good. But in the state of Texas, let us be the forerunners and doing it the right way, the responsible way. When I've inquired about this program, I'm asking, who's in charge? Is the NCAA in charge? No. Are the universities in charge? No. We've got agents talking to coaches rather than families. I don't want to destroy families, and we shouldn't want to destroy families. Again, the state of Texas should be the forerunner in doing an NIL program appropriate. And I'm going to give you this suggestion, and that's why I asked the author of this bill to take an amendment, that any funds earned go in a trust fund, and in that trust fund, they're able to access that trust fund either after they graduate college or a certain age where they're responsible. So indeed, they can learn how to manage that money. But we cannot destroy families by giving youngsters too much money too early. Members, I vote no on this, and hopefully I can get your support.
The chair recognizes Mr. Little to speak against the bill.
Thank you, Mr. Speaker. Members, I don't have any notes upon which to draw here, but I will tell you that I'm going to express some concerns that I think a number of you internally share as well. We have an ongoing deconstruction in this country about what we believe about college athletics. I was a college athlete myself. I wasn't as good as Representative Jones or some of the other people in here, but I had these experiences myself, and there is value to amateurism, not only in the state of Texas, but throughout the United States, that attending a university and representing that university for purposes of going to school and gaining an education is actually an important thing. And what we have done as a country is begun to deconstruct that and cheapen that experience to the point where the people who are competing on your television on Saturday afternoon in college football are just a series of subcontractors there for our entertainment. And we have to suspend our disbelief somehow that these are not professional athletes, which they very much are. It's not about the universities, and we certainly don't. The state of Texas takes a backseat to no one in collegiate athletics. First of all, we do not need to follow Florida. We don't need to follow other states and what they're doing and allow our universities to essentially make these athletes employees without providing for all of their benefits as you would if they were employees, and two, being responsible to honor whatever obligations and contracts you enter into as a university, because public universities are immune from suit.
Mr. Speaker,
Mr. Raymond, for what purpose?
when the gentleman is ready, if he would yield for a couple of questions.
Will the
when he's
gentleman
ready.
yield for questions?
I yield.
The gentleman yields.
Thank you, Mr. Speaker. I know where you're coming from, and I agree with you in many ways. I've seen this coming for a long time, though. I felt like for some time now, there's so many sports programs that are making so many millions, essentially off the labor of young people who are very talented, right? And so I felt like sooner or later, they were going to get something more than a scholarship and a hamburger, okay? So here we are. It didn't happen, it didn't roll out the way I had hoped it would, but it has. So you may have said, and I may have missed it when you were back here asking questions, but I want to give you a chance to tell us, or to tell me, what do you think we do at this point? How do we move forward? Because you're not for this bill, right? You're against this bill.
I am against the bill,
But
Representative Raymond.
tell me how we, is there putting a genie back in the bottle, or is there, universities like, I'm a UT guy, right?
Yes.
So they're doing well, and they're going to do well under this system. But the Texas Techs of the world and others, what do they do?
Yes, Representative Raymond, I think those are good questions. I don't think there is a way for us to close Pandora's box. My concern is that the state of Texas and the legislature not open Pandora's box even farther and end up in an unintended place where each university essentially has a set of employees rather than amateur student athletes. I understand that young people should have the right to be compensated for their name, image, and likeness. We saw it started with the video game litigation that
Right.
resulted in allowing them to be compensated for their name, image, and likeness. But what has happened is the people who want to compete at a higher level have extrapolated that into where we are today, where college athletes, young men and women, are essentially just mercenaries. They're not bound to the university
But I'm asking,
anymore.
but again, the genie's out of the bottle. So I'm trying to figure out, and you're a smart guy, and you've clearly given this some thought, is what do we do about the other university? I'll just put it to the universities that maybe are supporting, or fan base, or legislators who are supporting this, not because of the University of Texas, they're not supporting it because of Texas A&M, but they are supporting it because of others. Mr. Tepper's from Lubbock, represents Lubbock. My guess is Texas Tech has something to do, his support of Texas Tech. So I'm asking you, how would you move, what would your bill look like if you wanted to try to bring some parity, if that's the right word?
I don't think we can obtain full parity. My concern, Representative Raymond, is that if we enter into this bill, you won't see any more Cinderella stories. You're not going to see the Abilene Christians, the Rice universities, Baylor universities be able to attain to those levels because they're not going to have the same access to capital that the large universities in Texas will.
But my sense of what he is doing is giving them at least a chance to reach some level. I said some level of parity. It's not going to be parity, I get that, but how do they move forward? What's the Mitch Little solution to helping those universities and the athletes that go to those universities have some chance at compensation of that? That's what it is.
They have that chance now. If Abilene Christian wants to enter into NIL contracts with their collective and the student athlete, they have the ability to do that.
So you think just leave it NIL as it is, period, and then hope that...
I wish we could hit the rewind button and go back in time.
Right.
But we're not going to be able to do that. So my suggestion is we not expand it any further at all.
All right. Thank you.
Thank you, Representative Raymond. I conclude.
Chair recognizes Mr. Anchia in favor.
Thank you, Mr. Speaker and members. I know this discussion has been confusing for many. I wanted to offer a perspective about this bill that maybe some have not considered, even though it's been mentioned very briefly in the debate. Student athletes have been receiving payment for performance for decades. There is nothing new under the sun, whether they've been receiving it directly from universities, under the table from boosters, or now transparently through the NIL, which I think is the right policy. It has been happening. And I agree with paying athletes, by the way. I do, unlike the prior speaker, I do not want to return to amateur athletics. These students, these student athletes, put their bodies on the line every day in very violent sports. And you may have all the promise in the world, but your knee blows out, your shoulder goes, you get concussed, and you're done. My view on this is that these young people who are making billions and billions of dollars for college athletics should be able to, through their talents, monetize that in a fair, legal, and transparent system like the NIL provides. Now, the one thing I want to emphasize for everybody, and I saw this firsthand, I was at SMU when we had an awesome paid football team in 1986, and then we got the death penalty, and since then, everybody has said how hypocritical it was to put the death penalty on SMU, and it took almost 30 years for
Mr. Little,
our
for what
program
purpose?
to
the
respond
gentleman yield for
and
questions?
to come back. Not at this time.
Not at this time.
Mr. Little, I'll take your questions after I'm finished. However, members, it is expected that the NCAA is going to rescind its rule very shortly. If we do not pass this bill, and candidly pass it overwhelmingly with 2/3, there will be nothing in state statute to conform to these new state rules. What will it do? It's going to advantage Oklahoma. It's going to advantage LSU. It's going to advantage all the other states who have been first movers in this regulatory structure so that they can, in a safe, legal, and transparent way, pay their players. And Texas will be left without a regulatory framework to do so. And that is a problem. So, ladies and gentlemen, it's very important, as this bill does, it aligns state law with the two anticipated changes of the NCAA. One, removing the prohibition on institutions from offering compensation for NIL agreements. And number two, removing the restrictions preventing prospective student athletes from entering into NIL agreements in exchange for university admissions. Those are the two things it does in state statutes. Unlike the prior speaker, we are not returning to amateur athletics, and there is a very strong argument to suggest that we have not been in amateur athletics for decades, members. So please support this bill so Texas and Texas student athletes are not left behind.
Mr. Little, for what purpose?
Mr. Speaker, does the gentleman yield for questions?
Does the gentleman yield for questions?
I do.
The gentleman yields.
Representative Anchia, you're an attorney like me, right?
I am.
Okay. When you read this bill, what will there be left to distinguish a collegiate athlete who is engaged in NIL activity directly for pay from the university from an employee of the university? What will be left to distinguish that person from an employee?
That is a fair argument. That is a fair argument. However, I think that we can deal with that fact pattern and deal with the other laws that come to bear, as you suggested in your back and forth, outside of this bill. We don't need to do it here. There will be many other opportunities to deal with the relationship, whether we want to have it be a respondent superior relationship or some other type of relationship. I just don't think this is the place we have to do it, and this is not the moment to do it, because if we do, there are going to be disagreements about the specifics of those things. This is a very narrow rifle shot bill that really needs 2/3 so we can have it in place when the when the NCAA rescinds its rule, so that we have some regulatory framework. I agree with you that the issues that you raise are legitimate, just not in this bill.
Well, Representative Anchia, isn't it true that if you create the environment where that person's conduct at the university appears to be that of an employee, they're compensated for their labor, and the university has the ability to control their conduct, that the cascading effect of those things can be to create an employee-employer relationship between that person and the university?
If it is determined that it, by a court or by a regulatory agency or even by the Higher Education Coordinating Board, that it is that type of relationship, that it is an employee-employer relationship, then the entire regulatory framework that we have in place today would be brought to bear. But I think
it would be destroyed, wouldn't it?
That would be a question for another day, candidly, and not to be dealt with in this bill, because I don't think we have the competence at this moment in time to do so.
Well, Representative Anchia, respectfully, this reminds me of that concept of Chesterton's fence. Are you familiar with that concept?
No, I'm not.
So Chesterton's fence is basically, the concept is when you see a fence, before you tear it down, you ought to think about why it was there and why someone put it there. The current state of affairs in college athletics is a set of unintended consequences that has led us to this moment. And my hope is that the legislature will see it for what it is and say, let's tap the brakes and consider what legal ramifications of this bill or these types of bills are going to be that might result in an employee-employer relationship, Fair Labor Standards Act, and a number of cascading legal consequences.
I appreciate that. But it is also the case that we pass legislation all the time in this body, and we come back and adjust it and fix it because it is impossible to foresee every consequence from a bill. I will say further that we are responding in this bill to a change in the legal framework, which is the rescinding of the NCAA rules.
And
so I appreciate your Chesterfield, I'm sorry if I'm mispronouncing it,
okay,
fence analogy, but I just think it is not the question for the day.
And Representative Anchia, I think you pointed out my concern is that oftentimes in this building, bills are passed and laws are created without foreseeing those consequences. And so the purpose of my questions to you here today are to try to help everyone in this room foresee the potential consequences that I think you and I agree are possible could come to bear.
Yes, and I think they're fair-minded consequences. I don't quibble with your analysis. What I do believe is that we need to put something in place today given the NCAA action that is imminent. And furthermore, and you will agree with this, I have still never seen the perfect bill in this body.
Thank you, Representative Anchia.
Thank you.
Mr. Speaker,
Mr. Lambert, for what purpose?
would the gentleman yield for one question?
Gentlemen, will you yield, Mr. Anchia?
When you said gentlemen, I was confused. Yes, absolutely.
Gentleman yields.
Absolutely, Mr. Chairman.
Representative Anchia, are you aware that the NCAA has been dealing with this whole issue of employer-employee status for the last 50 to 60 years?
Yes, this is nothing new under the sun, certainly.
Thank you.
I appreciate you.
Representative Jones against the bill.
I think this is the first time I've come up here to speak against the bill this session. I am a former scholarship athlete. I won 3 NCAA championships, and I won 1 United States championship and won a whole bunch of Southwest Conference titles, and I was a poor, broke college student, notwithstanding that my university was able to get money because of me and recruit great athletes because of me, because people wanted to come and compete with me. So I am not at all suggesting that athletes don't deserve to be paid for what they do. Here's my concern about this particular bill. First of all, when we compete, when we are on a team, we should all be equal, especially with the school. So if a school can now enter into an NIL contract with me, and I probably would have been one of those athletes back when I was in college to get an NIL contract. I'm almost certain of it. So now I have obligations with my scholarship, which requires me to be on time, make good grades, and all these things. But NIL is basically advertising for the school. So what happens when my scholarship conflicts with the NIL? And if an athlete is like me, where I've won all these NCAA championships, who's to say that another school doesn't say, hey, I want Jolanda to get into the portal and come to my school so she can win me NCAA championships. So then I'm stuck. So now somebody else is paying me more money. Is the school I'm leaving now going to sue me? Is that what's going to happen? Or if I get injured, which I have had 2 surgeries on my right knee, 1 on my left, clavicle problems, tore my Achilles. So am I going to lose my NIL because of that? And let me be clear, whether you want to say the schools that were illegally paying athletes like they did with SMU back in the day, and they got the death penalty, right? Back in the day when they got the death penalty, I don't care if we've been doing it even though we did it illegally. It's not right. So even the NIL athletes, which I would respectfully submit to you, when I'm coming out of high school deciding if I'm going to a college, I don't have the best lawyers reviewing stuff. I just don't. The university has the best. And this actually is a way to subvert pay for play. And it's definitely going to give the schools with more boosters and more money a definitive advantage over schools that don't have them. So for the most part, we're talking about, I guess, SEC, Big 12, I can't remember what all they are, all these new conferences they have. I just think that, at least right now, it is clear. If you enter into an NIL contract, some company gave it to you. You have an obligation to meet the contract with the company that gave it to you. That's fine. But it's not right that at a certain institution, I could literally have 2 conflicting obligations under those contracts, and then I'm stuck. And for the people that are saying, well, this is going to prevent us from being able to compete across the country, what about those universities? Let me be clear. I picked the students over the universities 1,000 times out of 1,000. The universities have boosters and they have money, and these little bitty old athletes, they don't have that. It's unequal bargaining power. And let me be clear, we should have never been amateur. There was no reason I should have been starving when I was in college and having to sneak to work. But this is not the right answer. Thank you.
Chair recognizes Mr. Tepper to close on his bill.
Thank you, Mr. Speaker. Members, this is a cleanup bill. This is in response to a court settlement that's going to come down and be finalized within 7 days to 10 days. Apparently, there's no state funds involved. These are athletic departments. This is Texas. We believe in our student athletes. We believe in football. And frankly, they deserve to get paid. And this is what this bill does. With that, I close.
The question occurs on the passage or engrossment of House Bill 126. A record vote has been requested. The clerk will ring a bell. Chair Representative Chia voting aye. Ms. Davis voting aye. Wally voting aye. Ramon voting aye. McQueenie voting aye. Ms. Isaac voting aye. Mr. Lambert voting aye. Mr. Wilson voting aye. Mr. Lopez voting aye. Have all members voted? Have all members voted? Have all members voted? Mr. Queenie voting aye. Have all members voted? There being 109 ayes and 35 nays, House Bill 126 is passed to engrossment.